All right, the court is calling 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced?
State, John.
John Hunter for Mr. McIntyre, Your Honor.
Are you Mr. McIntyre?
Yes, ma'am.
All right, State defense has filed a motion for new trial. Have you had a chance to review that?
I did review.
And are you ready to proceed on it? All right, so the court has read the motion for new trial. I think the motion for new trial clearly has the defense's arguments in it.
And we're off. A motion for a new trial has been filed. So what's at stake? Essentially, the defense is saying, hey, we didn't get a fair shot the first time. Let's run it back.
So with regards to number one.
Yes, Your Honor.
Any rebuttal?
Yes, Your Honor. And that, I believe that's the NCIC, TCIC argument, I guess, of the defense. Our position is that we did make it available during court proceedings, and they had access to.
Here's where it gets technical, but important. The TCIC, NCIC reports are like criminal background gold. The defense wanted copies. The state said, you can look, but you can't keep. Who's right? Stick around.
The actual TCIC, NCICs, and through our understanding of the policies that we can't allow them to duplicate or keep or make copies of, and that's by, I believe, state orders on that. So that's our position on that front.
All right.
Megan Dowling for the state. Just briefly, if I could address that point, and I want to reiterate the arguments that I made at trial, which is that 411.083 of the Texas Government Code is what governs the dissemination of the criminal histories. They were provided to Mr. Hunter, and that's stipulated to in the motion. He states that the state did provide him those. And so that is our position. It would have been a violation of law to allow him to keep them or to reproduce them.
All right. And then defense, because it's your motion for new trial, I'll give you the final response with regards to the state's answer to defense's number one.
Yes, Your Honor, and forgive me. I did not prepare to proceed today. I came to court because the law requires me to show you the motion within 10 days.
Yes.
And so I haven't, I wasn't anticipating actually discussing the merits of it today, but if the court.
Legal face-off alert. The judge asks a critical question. Did you receive the documents, or were you denied the use of them? And that distinction could make or break this motion.
Wishes us to proceed with that. Our position with respect to the NCIC argument is fairly simple. We cited you case law, which the courts have addressed this subject matter before and have recognized that it is covered by the Michael Morton Act and that it would be required to be produced. As a practical matter.
Well, you're saying produced, but the state is saying that they did produce it. They just didn't allow you to copy it or leave with it.
It was given to us on the first day of the trial. And in the process of trying to make use of it and note it down, we got into an argument about whether or not we'd be able to photocopy it, which we immediately brought to the court's attention. We had an argument in which the court concluded that we were not entitled to copies of it, which we
does the law say that you are allowed to make copies?
I believe that is what those cases that we have cited for stands for, that proposition, that it is producible under the Michael Morton Act in all ways that other discovery is producible. The state's contention that there is a statute that privileges it from disclosure, I think, is being misinterpreted.
Okay, they're not saying, and correct me if I'm wrong, they're not saying that it doesn't prohibit them from disclosure. They're saying, yes, we do disclose it to you, but you're not allowed to copy it or leave the courtroom with it. Am I misinterpreting what's being said?
That is their argument. Yes.
All right. So
we just disagree with that position. I don't think the law supports it. And we also would maintain, as we maintained at the trial, that as a consequence of, well, let me rephrase that. To the extent that there is any countervailing or overarching privilege that would run afoul of the case law that we've cited, Your Honor, about its discoverability, or that would limit our ability to use it from how we would otherwise be entitled to use discovery. I would maintain that privilege is waived by two separate independent actions. The first is, this isn't a This isn't a situation where we're trying to snoop on these people's lives outside of the context of defending Mr. McIntyre. He is indicted. The state made that decision. When the state or the government have a privileged interest in the privacy of certain sensitive information, and they elect to indict someone for a criminal offense over it, then they can't be in the position of being able to still hold on to that privilege. They waive it. Secondarily, they have run the TCIC, NCIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. They query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us.
Boom. The defense drops the Brady bomb citing Brady v. Maryland, which says the state must turn over evidence that could help the defense. But does letting them glance at it actually count?
Or they, for a petty
You're
difference.
saying that they were upset with somebody, that's why they...
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
So we're not saying that any NCIC, TCIC was queried without a good faith basis.
No. In fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland and every case that has come since it says that they have to give me that information. That
Okay,
is a
so
requirement.
then
So-
the main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC.
Hit the heart of the defense's complaint, not that they weren't given the docs, but that they couldn't copy, review, or effectively use them. Big difference and big implications.
With you.
We
Was
wanted,
that your...
we wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is, your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
All right, so let's start with this point. First point, state, when was the NCIC, TCIC given to defense?
Prior to jury selection, Your Honor.
And the prior to jury selection, was this the NCIC, TCIC that was given to the defense prior to the jury selection? Do you remember?
Let's pause. The judge wants clarity. Were the reports given to the defense before jury selection? Defense answers with a hesitant yes but with strings attached? Do you think that's enough for a fair trial?
Which witnesses those would have been?
It was for all witnesses listed in discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was, Your Honor.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination. But my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear
I want
because
the record to
court's
be
question
clear
is
too.
not accurate. I mean,
I want to know